Então, bom dia a todas e a todos. Sejam todos e todas muito bem-vindos e bem-vindas a esse seminário sobre LGPD da teoria à prática, que está sendo organizado em parceria entre a União Europeia, a delegação da União Europeia no Brasil, e a FGV Direito Rio, que é a Escola de Direito da Fundação Getulio Vargas, no Rio de Janeiro, e é suportado, patrocinado pelo projeto da União Europeia sobre Enhanced Data Protection and Data Flows. E, está sendo também não somente um evento, mas também um pré-evento da nossa conferência que foi postergada por causa do Covid-19 a 2021, sobre a CPDP Latam, a versão latino-americana da Computers Privacy and Data Protection Conference. E o objetivo do evento de hoje é começar a ter uma ideia do panorama nacional e internacional, não somente ao nível regional, mas também começando um diálogo internacional, transatlântico e também regional ao longo de todas as Américas, para entender como de um lado, como as implementações das diferentes leis sobre direitos pessoais estão sendo desenvolvidas,
are being developed, or how they have been developed for the past decades in Europe. What lessons may be learned in these processes, integrated into recent experiences? And in the second part of the event, we're going to talk about some topics that are highly debated but not solved yet. Relationship of personal data, elections data. But before we begin to introduce our panelists, I would like to hand the floor to Danilo Bejeda. Not only he's a friend, but we can also define him as a father. He's a father figure. So welcome, Danilo. The floor is yours. Thank you very much, Luca. I would like to thank Luca Belli for the fine introduction. And to be a father, this is very nice, but it also has high risks of the implementation of GPD, in which many things can happen. And eventually, but it has a lot of the risks, though. Thank you very much. I would like to remind you all that this event is being recording Portuguese, English, and Spanish. For those of you who want to prefer any of those channels, you have a switch on the bottom part of the screen. It says interpretation. It's a little globe in the lower part of the screen, and so you can choose whatever language you want to hear. So it's a pleasure to have this space here to introduce the topic. But before that, I would like to remind you the following. It's a pleasure to be here today. On the topic of protection data. So this, first of all, CTS is a place where I worked a few years ago, and today Luca Belli and Bahak, they still are receiving me and make me feel at home. So thank you very much for that. Because also we're in time and date. Today is 27th of November. So on the 30th of November 2010, was launched 10 years ago by the Ministry of Justice with CTS in Rio, the public consultation, the draft of data protection law. So this was done based on a public consultation, and this text that was launched for public consultation is what we are seeing today as GPD. This is the first public version. It's a text that has a continuous solution and today is a law. So that's why I wanted to highlight this alliance. And this is very important for the debate in Brazil. I hope this will continue to find mother borders, and the CPDP in the first version in Brazil, as the Olympics, for example, were postponed for 2021. Well, we really want to expect high participation, and this is a community, and we would like to invite all the people in Latin America for data protection. This is a community that grew for the past 10 years. From the beginning of this debate until today, it's incredible the amount of people that are interested. Before that, it was simply a discussion. It was a very impacted impression that this topic would not, let's say, go on or continue. So there are rules that were not, let's say, mentioned in Brazil, but really we are highly convinced that it was the opposite. We needed to have these conversations with the need to modernize your tools when we talk about personal data and data flows through harmonization of the tools and criteria or those who were practiced internationally. So this is what we observe today. This discussion has transcended, and that's what we're going to talk about. Application. Luca is going to present this topic of this, the application of these laws. So it is very important to say that the foreigners, the European Commission, Mexico, and Colombia, also Miravimia, I would like to hide that. In data protection, this is very important and is one of the 5 directors of GPD. And personally, I would say that I'm very the presence of Miriam here. Thank you very much for your presence. And also saying that we're going to have another panel in privacy and democracy. This is a draft that was discussed 10 years ago when it began, and there are external factors in the implementation of any legal text. Is very important to really mix or at least highlight in the Brazilian people something that could not be left apart. Data protection was really very important. The access to information, consumer rights. In 2013-14, we had a high impact of Edward Snowden that incentivized another law that also had another participation by the GDPR and LGPD. And it has handed a very, very important result. As you all know, for example, we had very important discussions on the use of personal data in the elections in 2018, for example. So we're going to have investigators and people and researchers on people that work in the front line in the verification of these processes, trying to do, let's say, a relationship with today's information. So this is all takes us to personal data, to to monitor, personalize, customize information, and all these tools with without this would be less uh, relevant. I would like to say, talking about a topic and the elements that are placed on the table, we have to define them clearly. We may continue with this event line. In democracy, the new, like say, the news this week, I can see too, the insecurity of information. 16 million users of the healthcare system in Brazil. The characterization of this healthcare system in Brazil is very highly accentuated. And it's also an international reference. This is why we demand a very important treatment in the data and sensible data. There was a situation due to a data breach that caused a reaction in the public medium saying that there is really this breach. This is very important, that treatment in healthcare policies of people that are very well known, for example, public people, and say that Brazil is in the middle of an election process. We'll have the second turn the elections in 2020. So the use of personal data in this final part of the campaign has been affected by the topics we're going to talk today. This is why I want to just highlight the agenda for today to contextualize really the information. I would like to thank all the participants here in Brazil, Luca, Fabo, Felipe, and I really hope this is going to be an excellent debate. Thank you very much, Danilo, for this last introduction. I think we can begin with this first electronic table in debate on implementations of the laws. We're going to have 4 speakers. Danilo already presented. Ayambima. And I would like to thank all of you for this participation. We want to highlight the creation of these very important regulations, and I would like to introduce the other speakers. Bruno Giancarelli of the European Commission and chief of the cross-border flows in data protection. This is very key, important presentation from his part, Angamalina also, to understand, for example, the situation in Colombia. Blanca Ibarra from the National Institute of Transparency and Protection of Data. I would like to begin with Bruno. The European Union has a tradition, it's more consolidated in data regulation. And this, we want to get inspired. I know it has a lot of history and the GPR, for example. Bruno, I know that you have more insights that are very, very important for our work, not only based on your personal experience, but nobody else can really open this debate in this first session on implementation of data protection.
Hello, can you hear me? Yeah, so bom dia a todos y a todas. Many thanks for the invitation. Many thanks to the, of course, Vargas Foundation. Many thanks also to my colleagues and friends from the EU delegation of the EU to Brazil. It's a pleasure to be back once again in Brazil, even if only virtually, and to see that there are so many colleagues and friends that are online. This is an area where clearly Brazil and the EU share the same values, common visions around the opportunities and challenge of the use of personal data. We also increasingly share convergent rules, and we believe that this creates enormous opportunities to facilitate even more cooperation or exchanges, building on the, of course, already very strong political, economical, historical, cultural, human ties. And this is true for Brazil. It is true for a large part of Latin America, Central and South America, where we see similar developments in the area of privacy, and a number of these partners of these countries are represented in today's panel. You have asked me to focus on the role that data protection authorities have in a modern privacy system, in the governance of such a system. Of course, these are very exciting times in Brazil, with the entry into application of the LGPD, with the setting up of the Brazilian first ever data protection authority, the ANPD, and Miriam will probably tell us more. And we are observing that with a lot of interest, and we are looking forward to work with our new partners in Brazil. I will try very briefly to maybe share some lesson learned from our experience of the application and the role of data protection authorities in the application of the main piece of legislation we have in Europe on data protection, the General Data Protection Regulation, the GDPR, which entered into application in 2018. Now we have 2 years of experience, and maybe there's some interesting lesson to learn from that. Not everything worked perfectly. You can also, of course, there's a lot to learn also from things that could work better, that could have worked better. But I want to would like to share a number of elements and developments with you. And the second aspect that I want to briefly tackle is the need for more cooperation at international level between privacy regulators, between privacy enforcers, and how this, I think, can contribute and can positively impact on citizen businesses and the data protection authorities themselves. So on the role of a data protection authority, I think clearly, probably that's the main lesson we've learned from the 2 years of GDPR. The success of any data protection framework depends to a large extent on its governance system. And by that, I mean essentially the role played by a or several data protection authorities. I will try to very briefly refer to a number of things we have been observed, and maybe around few questions. Who, what, and how. Who, I think that, and that's, I'm sorry if I'm stating the obvious, but the questions and the issues that data protection authorities has to face today are, first, so diverse, from mundane complaints of individuals, which might be of limited importance in the general economy, but for that individual might be very important in terms of access, in terms of rectification, to extremely complex issue around new technological or economic developments that you need. When I'm thinking about the who, you need a really to become an expert of all those issues, also that might have also impact, for instance, on, and we know, I know we will discuss this on even the very functioning of democracy, the electoral processes. You need to have a diverse pool of expertise, and therefore you need to combine personnel with legal and technological expertise. What the type of expertise you need to hire, of course, data scientists. That really makes a difference, and makes a difference also for businesses and individuals, so that the Data Protection Authority asserts its legitimacy, its authority, and can intervene earlier on by understanding the developments, and I will come back to that. The what, I think a big challenge, because any authority is, of course, facing similar issues in terms of resources, allocation of resources, priority, is to get, in a certain sense, the right policy/enforcement mix. I think that what also we've learned is that that mix between different type of functions, which are all equally important, but that mix and that focus may vary over time. And when I'm saying mix between different functions, I'm thinking essentially of three functions. The awareness raising function. As we know, legal frameworks in themselves cannot do everything. This is about developing a culture of rights, developing a culture of compliance, and that takes time. And I think that Data Protection Authority have an enormous role to play in explaining these rules, and explaining these rules to different audiences, from schools to business associations, from civil society to the world of education, etc. A second, of course, very important area of activities of Data Protection Authorities is enforcement. There was a lot of fear in Europe, to say it frankly and simply, that when the GDPR entered into force, Data Protection Authorities would transform themselves into some sort of fining machine. That has not happened. But of course, making a use and making a balanced use of your different enforcement powers is important if you want that those rules are taken seriously. We always said that the best fine is the fine which is never imposed, because that shows that your rules are sufficiently credible and dissuasive. What we have seen is that in those 2 years or 2 years and a half, our Data Protection Authorities have made a balanced use of their corrective powers, from warnings to reprimands, from fines to temporary or definitive processing limitation, of course, in light of the circumstances of each situation, of light of the gravity of the situation, but that's, of course, something which is essential if once again we want these rules to be taken seriously. And then last but certainly not least, guidance. One of the biggest added value, I would say the biggest added value that a Data Protection Authority can provide is this possibility to adapt the application and interpretation of data protection rules to a necessarily, and as we know it, fast evolving field as data processing, where the law has necessarily to stay at a certain level of generality, and has to be technological neutral, has to be future-proof. And therefore, you need an authority with sufficient expertise, with sufficient independence to be able to adapt the applications of such rules to those new developments, those new conditions in such a fast evolving environment. And often those developments were not even thought about, or could not even have been foreseen when the law entered into place. We didn't negotiate the GDPR so long ago, but I can tell you that when we were negotiating it, we were not thinking about, for instance, an aspect that you are going of certain abuses of data processing in the electoral context. We couldn't have thought, of course, of blockchain, etc. So what we have seen is that an absolutely essential role that European data protection authorities have played in the first year or so after the entry into application of the GDPR has been to issue detailed guidelines on the main aspects of the GDPR, with concrete examples, with checklists, with where possible Q&A type of format on the basic concepts. And then they are progressively moving after this first layer, and I'm talking about some 15, 20 set of detailed guidelines. They are now moving to, I would say, second wave of guidance, which is less about specific articles or specific rights or obligation of the legislation, but addressing the application of data protection rules in rapidly evolving areas, such as, for instance, as I was mentioning, blockchain, connected autonomous cars. This process of guidance has also allowed to develop innovative tools, which are very, I would say, which are very much needed, especially in the initial phases of application of data protection rules. I'm thinking, for instance, of tools addressing the specific needs of small and medium enterprise, even micro enterprise, which of course are the backbone of the Brazilian economy, as they are the backbone of the European economy, through toolkits, for instance, for small and medium enterprise, for micro business, to help them complying with the new rules through a series of very practical steps. I think I don't remember, but I think we developed something on the basis of 7 steps. Another in this guiding, in this assisting, if you want, a function that DPA can play. Another interesting tool is the one of regulatory sandbox. How you can, as a DPA, incentivize privacy-friendly innovation. I'm mentioning that it's done in Europe, it's done in Singapore, it's also done in Latin America. Our Colombian friends have recently introduced a similar, or are introducing a similar sandbox. And that is very important both for companies and data protection authorities, because those are tools to which companies launching innovative products or services can approach their data protection authorities to work with it on limiting the risk, the impact on privacy of generally very data intensive new products or services. It is good for companies because then they can, in a certain sense, they can incorporate compliance as early as possible in their designing, in the development of new product. And it's also good for data protection authorities because they can learn from the market and they can understand better those technological developments. So those are just 2 examples that I think could be of interest. This can work, and I'm now moving.
Bruno, I'm sorry to interrupt, Bruno, but I would just ask you to start to wrap up so that we can have all the presentations in time, and maybe we can keep some of the points at the end. I'm sorry. I will try to conclude very quickly. This brings me to my last point, which is the how. I think all this can work, and I think that
data protection authorities, in our experience, have been quite successful because people have seen that they, in a certain sense, roll up their sleeves to develop what I just briefly mentioned, but also to constructively engage with stakeholders, with the understanding that compliance is a dynamic process. This is not something that happens overnight. And therefore, dialogue, constructive engagement with stakeholders, business, civil society is essential, including and in particular in the development of those guidance, which in our experience are systematically put out for public consultation, which once again also allows to give, of course, a chance for stakeholders to submit their comments, but also allows to sometimes understand better what is happening on the ground, what are the consequences, intended, unintended consequences of the proposed interpretation. Understanding also better sometimes that there are already some good practices that might be incentivized. So let me conclude, and sorry if I was already too long. I briefly spoke about the who, the why, the what, the how. I think it's important that we also understand that data protection authorities, in a certain sense, the message I want to is expect a lot from the data protection authorities, but don't expect too much. Don't rely only on data protection authority for successful enforcement, for successful application of a new data protection legislation. It's first of all a question of developing a culture of responsible and accountable use of data. Data protection authority are of course a key actor in that process, but now they are not the only one. They cannot do everything. There are other actors, and each of these actors have to play a role. Companies, public sector, private sector, citizens, civil society, and that's why an event like the one you are organizing today is so important. And I think the COVID crisis has been, unfortunately, a good example of that. For us, it has really been a stress test and a test for a case test for our governance system. And we've seen that, for instance, in the development of contact tracing app, the successful experience are where data protection authorities were involved as early as possible by the government, by public authorities in the process, in designing those, assisting in supporting the design of such apps. And that has, of course, a direct consequence on the trust in these apps and therefore the effectiveness, the uptake, and then therefore the effectiveness of these apps, which of course depend on how many people use them, download them on those smartphones. That's a very concrete example of the role and the beneficial role that a protection authority can have for the whole society. I will stop here. Sorry again for having been too long. Then I will, if there's opportunities and space in the discussion, I will also then say a few words on the international cooperation aspect of all of this.
Perfeito, excelente, muito obrigado, Bruno.
Thank you very much, Bruno. And there are some points that I would like to highlight and that are very important. The need of cooperation in this pedagogy, for example. This is very interesting to have this in place. We cannot only trust, we have to really have in place education. These individuals and specialists. So this is very important, as you mentioned, to regulation, the legal and technical, all the aspects you've mentioned, but those specialists And we have to have a cross-sector transversal conversations, all the developers in technology. In this sense, the singularity of the Brazilian system is also that National Council in Data Protection, Danilo, was the first member of that council, and he can share with us his experience in development of national policies in privacy. I would like to invite our next speaker, Nelson. I cannot see him in the panel list, but Nelson, are you connected? Nelson, are you here?
Luca, desculpe, o Nelson, ele está com problema técnico.
Nelson has a technical connection problem, and he was at the airport. I think he had to leave. He's very sorry because he couldn't participate. So I would like to hand the floor to Blanca Lilia Ibarra, that represents the authorities. The National Institute in Mexico, a huge country in Latin America. This is a very essential topic, and we have the honor to receive Blanca today. Blanca, you have the floor. Thank you very much for your participation. Thank you very much. It's a pleasure to be here with you today. I would like to say that on behalf of my colleagues of INAI, I want to say hello and want to share with you a presentation in which, on one hand, adds to what Bruno just mentioned on the very important points of the importance in each country. We have to promote public policies, and we have to have a solid regulation, and also with a budget that enables us to operate openly in these policies and those structures that are so needed in order to be materialized, the effect of the laws. But also I would like to share with you today the Mexican case. I would like to begin, if you are okay with that, I would like to contextualize in which 121 countries we have agendas that are very important, and with general regulation, and 18 of those countries are in Latin America. There are 84 authorities, national authorities, and this, without a doubt, shows us how the topic is arriving to Brazil since 2 years ago with a very important regulation. It is true that each time those laws in countries such as Mexico has to be reviewed and adapted to the new times. I will speak about how the pandemic has potentialized the risks in personal data due to the use of new technologies and the applications. But I do believe that the presence in so many countries in data protection laws is a symptom of the need to take advantage of the digital revolution, but also not to we have to really take into consideration the risks that the data is managed through the new technologies. The access to the digital tools today is essential. Great part of our activities, as we are, for example, today connected, depend on that. For example, the CEPAL said that in the pandemic, the use of telemarketing, teleworking has increased in 60%, 69%. So education online, 60%. Up to June of this year, there's 44 million people. More than half of the population are using internet for their activities. So this is why it's so important to be connected and to be helping and collaborating with the experiences in our countries when we talk about personal data protection. Nevertheless, the expansion in the use of technology has been traveling hand in hand with the risks for privacy and personal data protection. And naturally, this generates the enabling of activities. So the illicit activities. So we have to have a solid legislation that may protect the personal information for people. And naturally, with this, the protection of other rights for the individuals. So digital security is fundamental. Internationally, we can observe that if we applied security standards that are appropriate for data protection, there are incentives that generate better international agreements and cooperation. This also enables economic growth through e-commerce that today is in the peak of the activities due to the COVID-19 pandemic and the specialization of human capital, generation of jobs, competitiveness, among other aspects. This gives judicial security for those who do these transactions, and regulation framework also defines the limitations of how personal data is going to be used and gives a people power to be able to use that information, and establishes obligations for the responsible people, actors in the public and private sector. Briefly, I will mention the Mexican case. Here we can see in the federal constitution, when we have this fundamental right, personal protection data, we also have federal law in protection data also, and we also have a general law of data protection, personal data protection. It comes from 2010. Individuals, the public sector is much more recent from 2017, and you can see established their principles and duties to guarantee the adequate use in the data protection. So in the international experience, Bruno has mentioned, it showed that the can be a problem, but if we do not have the regulation, this may have impacts in the people, in lives of the people, and make them not control the situation. So I would like to highlight that, yes, in Mexico, we have had the experience of other countries and judicial traditions on data protection. And there is an institute that is the INAI, where we're in charge of having the access to public information, but also in the protection of personal data based and using the faculties granted by the Constitution and the laws that I just mentioned. And our norms establishes principles, just like to observe if it's something is illicit, the loyalty, proportionality, among others, just such as premises to guarantee the people power decision over their personal data. And these laws also foresee let's say there's an organization, national organization, but there are 32 local organizations that impose the rights on personal data in each federative entity. In this line, I would like to highlight the universe of, let's say, the repetition, as 18% correspond to personal data. This means that it's a challenge. It's that we have to promote that the people understands that they have the rights to protect their own information, and they can use the laws to ask, to inquire, and to do a follow-up of the treatment of their personal data. On the same line, there's a low percentage of resources of revision that are presented to the INAI when people are not satisfied with this information. So when we talk about the international cooperation mechanisms and cross-border, our countries subscribe the treaty, Mexico, United States, and Canada. And here there are specific disciplines in which we require the needs of economic agents to participate in the commercial exchange and investments in the region. For example, just to mention Chapter 19 of digital commerce not only acknowledges that the e-commerce promotes economic growth but generates opportunities and development, also highlights the importance to have frameworks that promote the trust of the consumer. We're talking about this level where we see these laws that are prone to protect the personal data. In 2018, we had an experience too, and it was approved to add Mexico to the European Council for the Protection of People regarding the treatment, automated retreatment of data in personal character and its additional protocol seeking harmony between the fair treatment of personal data and the free possibility to for the economic flows. So, like the idea is have the laws of international cooperation, have the assistance, and manage in order for the people and the states can really approach the government to receive the assistance when talking about data protection. This also is a benefit for Mexico, a shared responsibility with 55 countries, and is much more effective internationally. Well, this agreement has to be adapted to the new needs, to the new environment, and entering a modernization phase to confront the challenges. And a process began to align with the general rules of data protection, and the new agreement updated is open for you to see. It's important to highlight that this seeks to maintain the general character and technology of and technological of these dispositions to have the coherence and compatibility with other frameworks and open character that grants a very important feature. Mexico is very interested to go to the 108 agreement, but we have to do some updates. But we are working to achieve the status of third country in data protection according to the European Union. This status is guaranteed enough to have international transference in data from the European Union, and it requires a level of protection. So according to the European norms, this is urgent because the world is advancing, is interconnected. It shows us and really that we need to adopt new measures to enable the society to take advantage of all of this and to advance towards the digital economy. And it can enable the companies to transfer personal data to the European Union or third parties that have this same acknowledgement. And we have to highlight that the INAI has not been, it's not been easy. The budgets are limited, but we need to maintain the presence in international spaces, just such as this one today. That is really very important, and we would like to thank you for the invitation. INA is a member of Ibero-American Protection Network with 16 authorities in different countries in Latin America and Europe and Africa. And the objectives of the INAI are to promote initiatives and projects, relationships with the data protection to strengthen the exchange of promotion and promote another activities. INAI is also part of the Global Assembly of Privacy. The objective here is to discuss topics and promote the law application conformed by 130 authorities and institutions in more than 80 countries. It is very important to end my presentation saying that we think that in Mexico has to follow, I think it can be interesting for you too, to strengthen the data protection. For example, For access, we think we have to update the law naturally that regulates the private sector in order to respond to the economic changes. It would be desirable to add principles on technology. So when there's a technological development, like Internet of Things, cloud, for example, we have a regulation that is aligned. On the other hand, we think we have to strengthen cybersecurity strategies according to the data of banks in Mexico. We are one of the 10 countries that there's much more theft of identity. Interconnection of the system has increased for the entry points for the cybernetic attacks. These are threats that are growing increasingly in the organization. Third challenge, according to the private sector, has to do with schemes of self-regulation that seek to complement the norms in data protection and to meet the personal obligation. For example, some objectives in this scheme would be to promote that the responsible individuals promote good practices for the compliance of data protection, and they also have to have certifications and to enable transferences with third parties that have self-regulation schemes. When these schemes really are in place, we can protect data, and I'm pretty sure that the processes of the companies are according to the norms. On the fourth part, one of the main challenges is to promote protection data culture. According to a poll in Mexico, said that around 95.9% of the population over 18 years granted the data information or personal information to an organization. Only 18% of the people knew their rights of access, cancellation, or they were aware. So this is why it's urgent that among the countries we have to cooperate and help to promote actions, and we can really put in place mechanisms to have this right due to the increase of the digital platforms. The digital revolution is a huge opportunity to promote e-commerce and economic welfare and a sustainable development. But there are challenges according to the data protection. So this is very important, the collaboration among the governments, the companies, and the users to find the solutions. And among the authorities that we have, there's a huge responsibility to help in these objectives. So I would like to end my presentation, and I will be here for any questions you may have. Thank you. Thank you very much, Blanca. Your presentation was very interesting because you highlighted some points that are needed in innovation. First of all, I would like to say there's an element that I didn't know that existed. For example, how the European Union, on the other hand, and how it's being built in Mexico and also in Brazil. So we have to really understand the differences in these three situations. There's another very important aspect that you highlighted, the need for a budget and the resources. This is fundamental. The regulator really needs a budget in order to meet all those aspects. We have the technology, we have the human aspect, and we need to develop really with no budget, it's very difficult. In Latin American countries, it's fundamental, the connection between cybersecurity and data protection. LGPD in Brazil imposes the security with a basic principle. this is a concern. The data protection and security data, it has to be in all the agendas. So it could be, I think, easier to deal with the democratic challenges, technological challenge that we have today, if this principle of data security was in the initial draft of whatever processes from whatever country. As Bruno mentioned too, this is very important, but it's very difficult to really understand the need for this, um, really to put it in place from the public sector, developers, and the civil society. So uh, this very gives us really an idea to arrive to the Brazilian land. So, Miriam, again, it's an honor to have you here today. Miriam is a very dear friend of mine, and we work together several topics. It's a pleasure to see a person with so much talent, experience, that you were selected for a very difficult task. So you have the floor, Miriam. Thank you very much, Luca. I would like to say that for me, it's a huge pleasure to participate in this very important table on together with Danilo also, with his work in LGPD, and also I would uh, and Dr. Blanca also, Dr. Bruno Giancarelli, they are examples that we have to follow and adapt here in Brazil once we are beginning with this work of building the protection data authority. So it is very interesting also and relevanting that we are here. This is the first launch of the public consultation that generated LGPD 10 years afterwards. For me, it's an honor. It's a huge responsibility to participate in this first composition of the LGPD. So we know the challenges that we have in order to really have this design of authority that has been designed by all, that been designed by the LGPD, and we are in the first days of the implementation. I would like to say also that NPD is a collegiate with 5 directors, and we are in an initial phase. Institutional part is we are in a very important phase in this process because we want to establish a strategic plan, define priorities. So here I bring a personal perspective on the challenges that we have to confront and some information of the phase we're in and how is the discussion in Brazil going on today. I would like to begin by saying that in Brazil, different from the other experiences of other countries such as the European countries that has decades of this process and it's mature, the discussion in Brazil is recent, maximum of 10 years, but we are beginning to really float and this information is at the same time of the impact of the digital transformation. These technological changes that promote different personal treatment of data. So this also enhanced by COVID-19 that accelerated this process of digital transformation and brought our own challenges. So in Brazil, the challenge is doubled due to the absence of a history of data protection or culture or to the speed of the transformation in technology and the changes on the business models, platform economies, connectivity, and that society in which the data have a very important role. as an input of the different business models, input for the government too, and at the same time with the projection of a human aspect that people are much more aware of this connectivity. So in Brazil, there's a discussion that we are beginning to have in a practical way. Before LGPD, there was norm environment fragmented, consumer defense, for example, some regulations in public and private sector, but now we can see the LGPD seeking coherence, systematization of a basic standard that unifies the laws of data protection in the economy and also the public sector. As you mentioned, Luca, this is a ongoing discussion when we explore the fundamental right of personal data. And this discussion has two front lines. First is what is happening in the Federal Supreme Court with specific cases where there are constitutional parameters of controls of the rights associated. And at the same time, there's a discussion in the National Congress with an amendment seeking to acknowledge the fundamental right of data protection that goes moreover for example, the private data that are embedded in our constitution. So this is a very important moment. This is a boiling moment. And also Doctora Blanca, also Bruno too. There are many countries that have laws, for example. We want to really go towards that trend. Our challenge, as many other countries, is to understand those laws as a seeking and balance between the economic value and the input, but also the projection of a human aspect related to a protection. It's a duty of protection on behalf of the state. Our model is inspired in the European model. As it's very well known, is a model that has a responsible authority to put it in place. LPCD is the authority, a fundamental part of this jigsaw. And I would say this authority requires, due to design, certain characteristics that are institutional, that we're still building. The current design is far from the ideal, but we all have a vision where we want to go, and that is the work we're doing today. ANPD has several roles, like many other authorities, normativities, fiscalization, protection, and it's a huge challenge to build an environment where we can have judicial security and people understand their rights, but also that the companies understand that what are the business models that are admissible, and the people understands the limits and possibilities in personal treatment data. So in this sense, I think the huge challenge is to advance in this process of building to generate more trust, to avoid something that's undesirable, the judicialization. For example, this is a phenomena that we are seeing, and it's not good for anybody due to the fact of the inconsistencies and generates a lot of confusion.
Ponto que eu queria mencionar é que no Brasil, assim como mencionado pelo Bruno, existe também a necessidade.
In Brazil, as also Bruno mentioned, the need for any regulation has to have their authorities. So we have to assess public consultations, and we have to see the addition of any norm. This is hand in hand with the role like orientation to link the logics. It's a regulation in which not only under a control of one person, but really grant the opportunity for a lot of players. ANPD is born in an uncommon scenario in public administration because it's born from zero. What is more common is that there's a general coordination, has more responsibilities, and it transforms in a department, there's then a secretary, and Danilo knows that COM was a department, was a secretariat. In certain moment, we thought it could be a ministry, and we could not know what would happen, but it was born from zero, with authority, and with the autonomy, technological autonomy of non-dependence on other organisms, has a orientation role. And it's a huge challenge when we acknowledge that in Brazil and in public administration, there was no tradition to see this aspect. So we are faced with challenges that like finding a physical building to have the offices. Now we have also a technical body. There are interviews ongoing, selecting candidates for different positions. And I would like to say that I'm very happy, as suggested by Bruno, we are seeking for professionals with different formations, economic experience, and other experiences, because we need that knowledge in order to understand the technologies, the business models, to understand the expectations and the realities of the data and the companies and the public sector. So it is important to say that administrative solutions of LGPD are going to be from August of 2021. So we are really doing this guidelines before August 2021. So I hope I was clear with my presentation. The approval of LGPD was a very important step that brings us closer to other countries, Latin America or other continents. And in fact, these steps require a second phase, that is the constitution of the Authority of Data Protection with the necessary characteristics to really oversee this mission. And another comment is that when developing another culture, this takes time. And due to this, we need to, for example, in Brazil, public and private sector have to advance in the understanding of these regulatory tools, regulatory sandbox, for example, regulations through a dialogue, but also incentives in order for the sector to really advance and create an environment that is of security for all, for the companies and also for the public sector. All of us in LGPD, we are aware of the responsibilities that we have and that physically if we have, and talking on the perspective, let's say the newborn in this panel, I'm pretty sure that with the exchange of other colleagues in other countries and the academia, and this is fundamental to implement the LGPD aligned with the best practices, international practices, and understanding the mistakes and the successes of all. So thank you very much for the invitation. Thank you very much, Miriam, for your excellent presentation. I think you highlighted very key points. And then we're going to have the possibility to have a question and answer session. I believe that in this dialogue, we have two fronts. In international with other partners, the complexities of this society in the private sector, for example, and the public sector in a country in the Brazilian context where the law was launched and the digital evolution really hadn't begun when that was launched. So really, when we have to be prepared. Really our task is not only to build a new priority, but to implement coherently the law and how to build data protection culture and try to communicate the importance of data protection to 210 million people. This is going to be very difficult. But based on this optimism, let's open the session for questions and answers. I like to remind you all, we have a Q&A chat. We received one in social network on adaptation. Bruno mentioned the adaptation. Blanca also highlighted that one of the reasons for Mexico, for the arriving of Mexico to this adaptation is also to the possibility to enable that process through the European Commission. Brazil still has an adequation process because the authorities, we are still lacking authority. So what was shared really is what are the tools, existing tools in the regulatory frameworks to certify the adequation of a country to the national system. If we're talking about in the European countries, I think this is interesting to see if Miriam has any highlights on this. I would like also to hear Blanca, because I really don't know if Mexico has a system to really adapt. Please, I think we would like to hear your highlights on this question.
Bruno, if you are hearing us.
Bruno, if you question, do you have any highlight? Adequacy decisions, and what is the process that you can have?
I cannot hear you, Luca. Luca, I cannot hear you. I cannot hear what you're saying.
The adequation processes.
Can you hear me now?
Hello, hello, can you hear me? I think Bruno.
Now I can hear you.
See? Now I can hear you. I'm going to repeat the question, Bruno. The question that was shared, the adequation, which are the mechanisms and what are the criteria that enable to make a decision of adequation, data adequation? When you have, for example, an international system, when you have an adequate system based on the national standards.
It's my turn?
It's your turn, yes.
Yeah, well, because I didn't hear the question, neither through the interpretation, no, but I understand it's around adequacy. But I think we should not focus. Hello?
Yes, we can hear you.
Hello? Okay, sorry, I think there's a connection problem. I think I will answer on adequacy, but I think this is not on, we should not focus on one.
We shouldn't focus on one transfer mechanism.
I think the most important point that also emerged from the intervention of my co-panelist is that we are in Europe, in Central and South America, increasingly working with converging systems based on similar safeguards, on a similar enforcement mechanism, similar rights, similar obligation, overarching legislation that apply. And that, of course, those conversions facilitate enormously data flows, which we know are essential for trade, are essential for cooperation between public authorities, are essential for social interactions such as the one we are having now. That's a very important point, and we want to work bilaterally with Latin American countries, but also, I would say, at a regional level, and this has been explained by the Mexican colleague, what the Ibero-American network is doing is essential from that point of view. And the standards, I always note that the standards and the GDPR were more or less adopted at the same time. And that's a thing is asking, we see that we share the same idea, that our systems are based on ensuring a high level of protection, but being open to data flows, being open to the world through a number of mechanisms, such as adequacy, such as the contractual clauses or other transactions. I think that's also a very important converging point, because we can work together to ensure that we develop our transfer mechanism. They don't need to be identical. They need to based on similar principle, can use them, and it can facilitate them navigating between our different jurisdictions. We have we can counter such as Argentina and Uruguay. I think that there are many more countries, and Brazil is certainly one. And I was very happy to hear what our Mexican colleague said. There are many more ones in Latin America on which we can indeed develop such a transfer mechanism or that are very strongly based on convergence. Colombia, further examples. So that convergence is very and can bring lead to very tangible benefits in terms of facilitating data flows. I think it shows how convergence, if I may say, convergence pays off in practice. My last point I want to make on this is
eu acho, Bruno, que temos problema de conexão. Então,
we have a connection problem, Bruno.
Work together on enforcement, because when there's a massive data breach or a massive privacy non-compliance issue, it affects our jurisdiction and our citizens simultaneously. It's not limited to one country, not limited to one continent. So I think there is an important added value for data protection authorities to cooperate together in enforcement, but also cooperate not only in enforcement to developing common interpretative tools, common standards, so to ensure a clearer legal environment for business operating in several jurisdictions. That cooperation exists in many regulatory fields, such as competition, tax, financial supervision, and there's absolutely no reason why it should not exist and be an increasing demand for such cooperation with data protection authorities, between data protection authorities. And this is also why it is very important that there is finally a Brazilian actor and a Brazilian voice in that debate, which can contribute to shaping that cooperation and those standards. We in the EU, we want to start that work with a very concrete step, setting up what we call is a data protection academy to favor exchange of knowledge, views, best practices, and experience between privacy regulator, and develop in this way cooperation on the ground. And of course, we want to open it to any international partners, including the new data protection authorities or the other data protection authorities that are represented today. I think there's really a need for also that exchange on the ground of experience, best practice, views, ways of addressing certain challenges.
Obrigado, Bruno, pelos últimos pontos levantados também.
Very important, Bruna. The idea of that Academy of Data Protection is very interesting. I would like to invite Blanca to give us her last comments before we hand the floor to the next panelists. So let us have 2 more minutes in order to share our final insights. Blanca, you have the floor. Thank you very much, Luca. Well, in Mexico, still, can you hear me? We don't have the qualification of third country, qualifying third country, but there is an interest to establish this dialogue, this conversation, and that we can begin the process with Bruno's office. For us, it's very important that we have that alignment in norms, but also involves the legislation power in Mexico. This is not a simple decision. Other dependencies have to intervene in the federal public offices like the economic secretary. We're doing some works with general secretaries in order to that in Mexico, we have a very solid norm, but in order to achieve that, we have to align and to adjust that in our laws
de los estándares internacionales que se requieren. Naturalmente hay que crear un comité interinstitucional.
We have to create an institutional committee, as with the Economic Secretariat and the Counselor, in order to have a normative convergence.
De que se deben de tener focalizados puntos relevantes como la seguridad pública, por ejemplo, que es uno de los temas que se verifica, el comercio y otras medidas de protección. Por otro lado, también es importante que en el caso de México, para adherirnos al convenio 108, se tuvo que hacer una evaluación previa que cumpliera.
In Mexico, we had to do a pre-assessment because it's a dynamic norm, and we have to review it constantly. So our federal law comes from 2011, it's more than 9 years. So I believe that it's also important for us to have a framework, regulatory framework. We have to review some aspects included in the norm. For example, we have to predict privacy by design, privacy by default, and other aspects that we believe that we have seen the limits of the treatment of personal data, and the use of privacy had to be adequately placed. So it has to be permeated and has to be aligned with public policies, because there are agendas in the priorities for the legal reforms. And as Bruno mentioned, we have to support in what is established in law. It is very important what is in the laws, in the legislation, but it's not all. We also have to see other socialization, for example, policies, education policies, because at the end of the day, this will impact in the lives of people, in the way we use and share our personal data. So Mexico is very highly interested into beginning this dialogue, and we're working with Bruno's office in order to advance in this topic. Thank you very much, Blanca. I would like you to close this first table, Ivar, with your experience. Then we're just going to have a little surprise at the end of the second panel. Thank you very much, Luca. The question is very clear because the most important challenge that the countries have is to find the interoperability mechanisms in their frameworks, considering there's a global economy and acknowledging that this is based on personal data. So to deepen that discussion is very important. It's urgent, not only for the need to have competencies for the businesses in Brazil, but also to assure that personal data can be treated and are protected. LGPD brings a mechanism portfolio in which there are mechanisms of adequacy. I would like to mention that, as said, we have a historic of dialogues in Europe, and I've had the pleasure to work with Bruno and also Carlos Oliveira is a very constant presence here. And I'm pretty sure this dialogue is going to intensify, and it's going to bring us good results with the construction of LGPD. We are aware and very happy with the opportunity to work with the European Commission, but also with other countries to integrate these mechanisms with the Ibero-American network so that Brazil makes part of this global community. I would like also to say thank you very much for the invitation. Thank you, Miriam. Before we go to the next panel, I would like to say that our friends in the project of international flows have something to share with us. This is a poll in which we would like to fill out this form and make this event a little more dynamic. What do you think? These are the questions. What do you think would be the most important priorities that the Brazilian authorities would have the next months? This is going to be a very important feedback for my colleagues and for myself. This is a survey which you can fill out. This is for data flows, and it will help us to develop some processes and to supervise these tasks we have up front. And also to understand the international cooperation. Okay, this is hosted sharing. 53% highlights education and guideline development for the implementation of LGPD. This is highly needed, and this survey is a feedback for all of us. We are very anxious to see how this new opportunity is going to be built. I would like to thank you all speakers for your participation. I would like to remind you that the objective of this event today is the first step to build that CPDP in Latin America. We want to be a platform where regulators, the private sector representatives, private sector, public sector can build together proposals, norms on how to promote this.
Mencionando esse algo de essencial nessa época interconectada. Dito isso, eu passo a palavra ao amigo Ivar Hartmann para a moderação dessa segunda mesa sobre dados pessoais e fake news.
Muito obrigado.
Legislation.
Bom dia a todos e a todas. É um grande prazer moderar esse painel sobre privacidade e democracia, fake news, eleições e dados pessoais. Eu agradeço, é claro, Luca Belli, Danilo, Doneda, e demais organizadores
and the other organizers
de enfrentar
for the invitation and for the
nossos painelistas esse tema tão importante, mas também de poder rever, estar junto com pessoas.
Panelists review the steps with professionals and specialists that are here today. In this panel, we're going to have 10 minutes for each panelist. And we're going to go through the agenda as planned. Then we'll have 10 minutes for questions and answers. And then we will have, let's say, 10 minutes for something that may arise. I would like to introduce our panelists, beginning with Rebecca Garcia, who is Public Politics Manager in Facebook in Brazil. It's a pleasure to have you here. Rebecca, you have 10 minutes for your presentation. Thank you very much, Ivan. Good morning to you all. As you can see, my hair has grown in this lockdown. I'd like to thank all of the panelists, Chico, Ivan, our moderator, on behalf of which I really would like to thank the invitation. It is an honor to participate in this event, a preparatory event for the conference of 2021. And please forgive the background noise, something that I cannot control. I would like to begin highlighting the fact that the fake news are not only very in place in Brazil and in the world, but is a very complex problem because it involves a diversity of manifestations, expressions, actors, behaviors, strategies, and also concerns and risks in electoral context. Facing the fake news with respect to the elections and democracy, there are no one solution and speedy solutions, because we are in a vertical pathway, in a constant moving pathway. And it seems that it's not been mapped enough and studied enough. Not only going through that path, we have to find how to walk through it. This is something that brings in efficacy problems, but there are higher risks that are considered with respect to fundamental rights. I would like to acknowledge and emphasize on complexity and information of the fake news, that it's also important to reflect and debate on other aspects, that what are the types of connections, what are the connections between data protections and elections, between data and information and protection. So at the same time, on one hand, the misinformation is not a typical aspect of data protection. When we think on data protection as a tool, as an instrument in which disciplines is a transversal character, online or offline, and private, treatment of data protection to use this. And also the misinformation is manifested in diverse ways with different actors, behaviors, and strategies. What can involve the use or abuse of data of the citizens. Saying this, it's important to acknowledge that data protection and privacy has a relevant role in a holistic approach than that complex phenomena recommends. In other words, data protection and LGPD are not, let's say, the solution. There's no one solution, but can and may have a very important part of the solution. At the same time, the approach facing fake news and protection data has to be compatible with privacy and data protection. For example, observing principles as transparency, promoting more transparency and controls, with respect to the information and the political propaganda. When we talk about approach, at least talking about regulatory approaches, today in Brazil, the main proposal is PL 2630. It's called the fake news PL that our colleagues just are discussing already. It's a project that, even though it's advancing with the quick processes in the Senate, it's a project that has some very concerning points that recommend detection and maturity. Points that concern not only for the risk of not solving the problems, but also to generate other negative aspects according, for example, to privacy. Apart from PL sign or as identified account, for example, the demand today of collection and verification of data for any operation. So this is concerning, and we should put more focus on this process. It's important to have effective collective understanding that may help us think about solutions that are more prone to be efficient. I want to say that the regulatory approach is not the way to go, because I have even participated in this debate in regulations in this aspect, but the regulatory approaches, as other approaches, have to consider the complexity of this phenomenon and also the tools, existing tools. Internet, LGPD, for example, there's a debate on the application for the next elections, but the election, for example, is forbidding the electronic registry. So also to avoid messages during the elections. I would like to highlight a point on election regulations, such as an instrument. The election reform of 2017 opened a space that needs more attention. This is the Article 57. So this is talking about solutions, digital solutions. I think my time is up. To end my speech, I would like to say there are other approaches, not necessarily regulatory, but approaches that have to be considering the complexity, the diversity of the ecosystem of internet, as in a general terms, the risk potential, the alternatives that are also available. And what is the approach of Facebook, for example? In summary, talking about the efforts of Facebook faced with the fake news, Facebook is acting for different pillars, main pillars. The first one is the removal of policy breaches, fake accounts, or votes, for example, when we're talking about elections, reduction of misinformation because it breaches the policies with independent agency, and third, information to support education initiatives, to give more context and information for the people, and fourth pillar, that is the expansion of transparency, transparency of what people see in the feed or their information. Also, the transparency in election information and propaganda. So, and in a specific context in the presidential elections, to identify, and Facebook is preparing in Brazil and other elections worldwide, for example, in the United States. And to share three examples in Brazil, I would like highlight for example, the joint work with Facebook and other businesses in the private sector have been very successful. Expansion of the libraries. Talking about the political propaganda, it's a library. And another example is the Candidate Central that enforces the importance to bring to the discussion and to fight against fake news, and also to build a data protection culture, to bring together the actors that are doing the campaigns and really in the eye of the storm of the elections. So this it has to talk about integrity of the elections, transparency of propaganda in Facebook, on some candidates or parties. On Sunday, we're going to have the second turn, more than 50 cities, but the initial balance is promising. For example, Facebook removed around 140,000 contents of election interference. The example was, one of the example was simply they were saying that the date was going to be different from Sunday. So here we can rest and say we are doing our job, it's constant, and really we have to understand the pathway we're traveling, and it's very promising. With this, thank again the year, and it's a pleasure to be here today discussing these topics with people that I so admire. I would like to keep on debating on these points, and moreover, thank you very much.
Muito obrigado.
Much, Rebecca. I would like to hand the floor to Thiago Rondon. Thiago is digital coordinator on misinformation too. Tiago, thank you very much for your participation. You
Bom
have 10
dia a
minutes.
todos.
Good
Obrigado
morning to
pelo
you all. Thank
convite.
you
É
very much
prazer
for the
estar aqui com
invitation. It's a
vocês
pleasure to
hoje
be
para
here
a
with
troca
you
de
today
experiência
to
e
talk
informações.
about our experiences
É,
and
Na
information.
nossa conversa de hoje, acredito que eu vou buscar
Today,
falar um pouco
we're
mais sobre a
going
perspectiva
to
de
try
que a
to talk about the
desinformação e o uso de
perspective of
dados pessoais é
misinformation and
também
data
desafio,
use protection.
de
This is a
cibersegurança, de
challenge in
segurança da informação.
cybersecurity and
Como
security
muito
of
bem a
information.
Rebeca colocou
As Rebecca
anteriormente, a gente vive
mentioned,
problema, desafio
we have
complexo.
a very
E
important,
vamos
complex
precisar fazer
challenge.
muita troca,
We need
muitos
to
atores,
do a
muitos
lot of
especialistas de diversas
exchange of
áreas vão ter que debater
information with
esse
diverse
desafio, porque há
specialists. We
muitas
have to debate
dimensões.
this challenge because
Como
there are many
a Miriam
dimensions.
também colocou no
As
painel
Miriam also
anterior,
said,
é fundamental ouvir
it's fundamental to
e
hear
compreender todas
and to
essas
understand
dimensões
all
nesse
these
sentido.
dimensions
Então,
in
por
this sense.
lado,
On
que a
one
gente
hand,
precisa, no ambiente digital, estar falando de
in the
confiabilidade,
digital
de
environment, we need
disponibilidade, de
trust,
integridade de informação
availability,
e de
integrity of the
infraestrutura de
information,
tecnologia.
and
Por outro,
infrastructure
também
of
a gente vai ter que
technology. On
olhar
the other hand,
questões de
we have to
processos
see
desinformativos
the
não intencionais,
processes of
intencionais,
misinformation that are
fraudes,
non-intentional,
vulnerabilidades
intentional
das
fraud,
tecnologias que fazem
vulnerability of
parte
the
dessa
technologies that are
infraestrutura.
part of
E
that
eu acredito que os
infrastructure.
dados
I
pessoais, de
believe
maneira
that the personal
geral,
data in
elas têm
general
papel
have
muito importante nesse
a very
debate.
important role in this debate.
Então, na nossa visão, bom
In
programa
our
de
vision,
enfrentamento à
a
desinformação
good
é uma
program
coalizão de
towards misinformation
organizações,
is a
partidos,
coalition
instituições,
between
especialistas
organizations,
com
parties,
foco
institutions,
no apoio e
specialists,
troca de
with
informação de maneira
focus on
ágil,
support,
Então,
so we can
o que
exchange
nós
information in an agile
estamos
way.
percebendo
We are
e que
seeing
com um certo sucesso no combate à
with
desinformação
a certain
essa
success
coalizão e que a
that
gente
this
consiga, de maneira
coalition
muito ágil,
is very
trocar
possible.
dados e
We can
informações com
agile, in an
comunidades
agile
de
way,
pesquisa,
exchange
servidores e
information
colaboradores
in
eleitorais, agências
international
governamentais,
and
organizações da sociedade civil
governmental
e as plataformas
agencies,
de mídia social, de
platforms,
maneira geral.
and civil society.
Então, aqui no
So we can
caso do
exchange that
programa de
information.
enfrentamento
In
à
this
desinformação no
case,
TSE, ele é
let's say a
programa com o
program
objetivo de
that we
detectar e
have
mitigar o
with the
impacto
objective to
de
mitigate the
maneira
impact.
geral, de tentativas de impedir
Trying to
ou as pessoas irem
avoid
votar,
that the people
de processos que
go
vão
to vote.
deslegitimar os
So
resultados
processes
eleitorais,
that
por exemplo.
people
E
that
para
make
isso a
this
gente tem buscado combate
legitimize the
sistêmico dessas
process. So
desinformações
we have
e são
to
diversas frentes.
really
E o uso de dados
see
pessoais, com
different
certeza,
fronts.
é uma delas. E eu não vou chover aqui um pouco no molhado, mas é importante dizer,
It's
que a gente
important
hoje
to
está
say that
hiperconectado,
today we
a
are highly
população
connected,
está cada vez mais
population
conectada, as
is highly
crianças estão usando
connected,
as redes cada vez mais
children
cedo.
are using the
E será que nessa
networks today.
revolução social e
So
tecnológica a
in
gente
that
também não está
social and
ficando
technological
hipervulnerável
revolution,
no sentido de
it's
indivíduo e
being
também de sociedade?
it's
É
becoming much
muito
more vulnerable. That is my
fácil a
question.
gente
It's very
comprovar que
easy
teorias
to prove
conspiratórias e debates
that
públicos eles são
conspiracy
cada vez mais
theories and public
distantes
debates are
da
more
nossa realidade,
distant from our
eventualmente,
reality.
seja nas redes ou em
Let's
aplicativos de
say in the
mensagem.
networks or
Então, para
message
isso, eu
apps.
queria
For
compartilhar com
this, I would
vocês
like to share
4 pontos
4
que
points
me chamam a atenção pessoalmente
that
sobre
call my
esse tópico.
attention on this
Primeiro, que é
topic. First
necessário,
of all, it's
apesar de
necessary,
difícil a gente
even
debater
though it's
a
very difficult to
desinformação
debate
intencional e não
the
intencional,
misinformation,
principalmente quando
non-intentional
se
or
envolve
intentional,
dados
mainly
pessoais e a
when we
integridade
have
do processo
personal
eleitoral.
data and
Esses processos,
integrity
de
of
maneira geral,
elections
eles ocorrem de
process.
maneiras
This
distintas e
happens
as
in different
estratégias
scenarios,
para lidar
and there
também,
are
para combater essa
strategies to
desinformação intencional e não
fight against
intencional,
this
são muito
misinformation,
diferentes.
and they are all very
Então,
different.
esse é um primeiro ponto.
This
O
is the first
segundo,
point. Second point
que
is
fica muito claro também num
that it's
processo
very clear
desinformativo,
of
principalmente
this
falando de
misinformation
instituições públicas,
process
democracia,
when we talk about
processo
democracy, public
de
policies.
desinformação, é o motivo dessa desinformação. Há
Is the
diferenças muito
motive for
importantes
this
quando a
misinformation. There are
motivação é
very important
política
differences
e
when there's
quando
political
a motivação é
information or
financeira.
motivation is
Isso
in the
também
economic part.
clareia
It's
muito.
political or
Acho que um
economic.
terceiro ponto que também
third
gostaria de
point
destacar é a questão
that I
do
would like to
território.
highlight
O
is the
território, o tamanho
territory,
dele,
the
as
size of
campanhas
it.
desinformativas em
The
bairro,
misinformation
município, estado,
campaigns in a
país,
state, a
uma bolha
municipality, a
mesmo
country
dentro das
is a
redes,
bubble.
elas acontecem de formas
These
distintas.
happen
E o
different
quarto ponto
ways.
é o uso de
And
dados
fourth point
pessoais
is the
também de maneira
use
geral
of personal data in a general
para
aspect.
desinformar, como
To
a gente pode
misinform
debater
as we can
desde questões
debate,
como microtargeting,
like
por exemplo, até
micro-targeting,
operações de
up
informação.
to
Mas eu queria colocar aqui um ponto que é bom
information
lembrar que não é
operations.
só o
It's
uso
important to
de dados
remind you that
pessoais
it's not
brutos,
only the
como dados
use
e
of personal
e-mail ou
data,
telefone,
email, phone
que
number,
faz
that
atualmente de chegar às informações em um processo desinformativo.
that make this misinformation. We have a huge challenge that goes moreover only the use of personal data. We see different mechanisms that many times we can talk with a person and not necessarily have a register of those data of a person. So in a technical aspect, we can see that evolution.
Que no decorrer a gente vai melhorando de lado,
that we are improving on one hand, but there are other things that are arising on the other hand.
De uma maneira muito simplista,
so in a very simplistic way, I believe that personal data in a misinformative process, non-intentional, we have a way to treat that. Generally, those informations are going to circulate due to behavior aspect, interfaces that the platforms offer, our need for consumption, and another important debate on civic policy, experience of the use of the platform, transparency in the decision-making. And this misinformation, non-intentional misinformation, can have support in that sense through platforms. This is more related to how the information and processes information sometimes arrive to a public, even though that person wants to misinform doesn't have the personal data. But on the other hand, intentional misinformation, a huge part is coordinated. It can be configured as an operation and can use personal data from a group to configure a microsegmentation. Or many times there's no need in a general sense, but something that is very clear inside an election process is the abuse of economic power or computational power to misinform.
Para simplificar também,
acredito
que
make it simple,
de combate
the focus of combat against misinformation and data protection is very important to have three items in a security of information: trust, availability, and integrity. This triangle is very important to be built as an operation flow in order to avoid attacks or to avoid misinformation processes, non-intentional or intentional. What we can do is that the platforms
ou talvez eventualmente falar mais sobre questão de data broker, né?
The data broker, which are platforms that can do that translation.
O alcance que você quer falar com essas pessoas que podem ter os dados brutos,
the way we can talk to those people that can have the data or not, I think it's very important to talk with those people, to demand a civic policy from the platforms and the institution and all the ecosystem that is part of this equation. So it's important to say that
por exemplo, conversar com as plataformas digitais para saber como
to talk with the digital platforms, to talk about how do they deal with the elections, to leave it publicly, to publish, for example, users publish contents where they can incentivize the participation, or what Rebecca really was saying.
Na fala anterior, então exigir
So to demand that is very important. Demand that from the platforms, transparency for all, to improve experience user in the design product. When there's misinformation, how to apply information in regards to
né? E novamente a transparência das tomadas de decisão. Mas, de modo geral, quando a gente percebe nesse problema complexo uso de dados pessoais, como eu coloquei, ele se distingue muito com relação ao tamanho do território, muito com relação à motivação e à forma com que é utilizado esses dados. Se em cidades ou territórios menores é muito simples comprar ou adquirir dados, infelizmente é uma realidade que é possível de realizar, por exemplo, tanto disparos em massa, num território maior, esses dados são utilizados para microsegmentação. E esses dados por amostragem também são um desafio. Né? Então, acredito que o grande desafio aqui para nós é trabalhar em políticas, tanto dentro das plataformas, tanto em ações de cibersegurança que possam detectar imediatamente vazamento de informação de dados pessoais e atuar em cima disso, como atuar. E isso é um debate muito importante que é fundamental para os processos de desinformação que vêm ocorrendo de maneira ampla. Eu deixo aqui essa minha mensagem, acredito que possa reforçar que não é um problema de uma instituição, de uma plataforma, ele é um problema complexo e a gente tem que envolver diversos atores no desenrolar aí dessas soluções. É isso, obrigado, pessoal.
Thank you very much.
Muito obrigado, Tiago. Então,
thank you very much, Tiago.
Passo a palavra para Clara Iglesias.
I would like to hand the floor to Clara Iglesias. She's a researcher in Berlin Social Science Center and associated to the Foreign Internet and Society. Clara, you have the floor for 10 minutes. Thank you very much. Good morning to you all. Thank you very much for the invitation to be here today. How are you? Rebecca, Thiago, Chico. In 2020, this was a very, very difficult year. We discussed about misinformation. I remember that in February, we participated of the Inspres in Sao Paulo event. It was the first event of the year with concerns of what's happening today, the municipality elections. I presented the results of my survey, and I really didn't know what was going to happen. We didn't know how much was going to be debated. Moreover, this year, we debated regulatory proposals that were introduced on justification against combat of information. And at the same time, for many months, we found uncertainty of the future on data protection that evolved, as Miriam said, but we really didn't know that at the time. This to say that I'm very happy to be here at the end of November to talk about misinformation related to election processes and data protection. Each proposal needed a lot of attention, so it's very important to do that today in regards to the elections and data. I am a researcher, and I focus on regulatory strategies. And I'm going to divide my presentation in two parts. I would like to share with you some findings, some concerns, proposals. They're going to mix a little bit, but I just want to share with you this information. Talking about some premises, what do we know? Tiago and Rebecca already said. I would like to try to be as succinct as possible. First of all, really misinformation is no news. It always has happened. With no precedent we have seen that process, that evolving the dissemination strategies. We can see them. They are based in an illegal use of data. It's been documented by the organizations, organisms, and the academy. Campos Melo did a very important article on this aspect. It's called The Hate Machine. And Rafael Evangelista and Fernanda Bruno that talk about a work that they did when the elections of 2018, they identified political contents, organizations of that contents, and decentralization and dissemination of the information. We already know, we can say that everything shows that the strategy has a potential to use that information more efficiently. Profiles, political preferences based on the data use, and it's going to be much more efficient over time. So it has much more potential to mobilize the people to really make decisions on public policies. There is no proof that these strategies really generate a vote. People, for example, going to vote for a candidate, and it's not because they had access to information. That has not been proved. And also there are some studies that say exactly the contrary. These campaigns do not have the potential to do that. This is shown by David Kapp in a test, confirmed also by the Berkman Klein Center in Harvard, among other teams. There's an article from Jessica Bowell Phillips in Internet Policy Reviews on that aspect. So the influence of that strategy, the results of the election, on the results of the election was not proven. But it doesn't mean we don't have to fight against that. These practices are not in harmony with our democratic systems because they come together with corruption, economic abuse of power, subversion, and a weakness of the trust in democratic institutions. This is also reinforced by David Karp, Hoffman too. This week, I would like to say that there's the book I'm just began to read. I'm not going to say a lot about the book, but it's going to be launched this week. The writer explores this part of democracy, media. Its relationship is more complex compared to the final result. What is really seen at the election, at the end of the elections, we know this is still very important to be regulated. When we talk about strategies, regulatory strategies, data protection has a very important role. I talk about several strategies, but what are we saying when we mention regulatory data protection in election data, for example? There are some countries that have, for example, a public opinion as a sensitive information. There's also some information that cannot be used in elections, like in Japan. There are some initiatives in restriction or, for example, in policies when we're talking about the elections. But I think that the proposals are advancing. Now, talking about Rebecca's participation. So it's important to say we have a lot of information. For example, the existence of bots. This is another aspect. There's a methodology to identify bots. There is a discrepancy amongst the academy to what to be used. There are studies done to identify bots that are questioned. There's no peer reviews on methodologies. Recently, Jonas Kaiser launched this year. I don't know if he has a peer review. Another very important challenge in election period. Communication was also always regulated. The criteria for regulation was the timing. 3 months before the election, varying from experience to experience. How do we do, let's say, there's that distinction in this digitalized world? I asked a question to the professor who has a very extensive work. How do we deal with that temporal cut in a permanent campaigning context? And he said to me, as investigators, what we can do is legislation framework. When we want to understand what is happening, we need to use a timing framework. We have to think about that. We cannot ignore the fact that it's very difficult to distinguish election campaign and what isn't an elections campaign. So I think we have to have that very clear. Ivar, I think I have finished, but talking about the proposals, the pathway, the approval of GPDS this year was very important. Not approval, the STF process, the approval of the authorities of data protection, even though we know that there are certain institutional aspects that are very important and have to be considered. But in that sense, I say it's very good to have those advances, but that text that is launched by the LGPD, do you think would have protected it for the campaign of 2018? That's a question I put out there. This is a question that has two answers. Depends on how you understand what is a public data. Because as Patricia Campos said, they were using cell phone numbers. That was, for example, available data. These were also used to create WhatsApp groups, but was that what they wanted to do once they authorized to use their phone number? I am saying this to open the debate because it's very difficult. And maybe we need to begin to talk about other fronts. LGPD is fundamental. We have to have that in place. What does it have to do? Is regulate. But this is the moment to bring other possibilities towards debate. These initiatives that we see to restrict the possibility of micro orientation, is it worthwhile? In some countries, for example, in Japan, it's forbidden during elections. You cannot do that. I'm not really questioning or putting my place in this debate, but I think we have to study that. But I think we have to be open to see other contexts and to assess other options that we may have. Thank you very much. I would like to thank all of you who are working on these alternative channels, all the initiatives that Rebecca mentioned, the work that the national institutions, civil institutions, research institutions are doing. It's been a very difficult year, but something very positive was to be in contact with you and to work together. Thank you very much.
Muito obrigado, Clara. E temos agora, então, antes...
Thank you very much, Clara. And before we open for questions, Francisco Brito, Internet Lab Director. Thank you very much for your participation. Francisco, you have 10 minutes. Thank you very much, Ivan. Can you hear me okay? I would like to thank the invitation, the opportunity to participate in this very important panel with colleagues in which we are opening this debate, in which our concerns are very highly aligned, because we really have to discuss these topics. This seems like a new cycle in regulation and technology in Brazil. We are beginning that cycle. We are ending the cycle when we opened with a civil framework, and then we're going towards another wave. I would like to divide my speech in two parts. The first one, it's going to be two layers of the story. The top layer is much more abstract in general terms. It's talking about the values that are in place, the values. And a tactical level, a lower level, on tactical and operational aspects, how we can put those values in place in practice, and what are the obstacles for the following years. Talking about the values, Clara said, to discuss data protection automatically makes that the information is less disseminated. The protection data from the electors, do we face that problem? Are we going to reduce the misinformation? That would be the first point. I really don't know, but really it doesn't matter to have this discussion, because to protect privacy should not only be a value, because this automatically makes us have the, let's say, it has a consequence. To protect the citizen privacy should be what is right, what is fair in the elections. So we have to seek that fairness independently from the consequence. That protection data value, talking about the privacy, moreover, intimacy and personality, is a value that has to be included, thinking that some values are very important for the elections that we have today, and the coexistence can help us understand as an integral, let's say, lecture. That would be, we have to have expression liberty of the candidates and the voters. We have to have respect to the voters and the candidates. Also respect towards human rights, population that are participating in that process, because they don't feel violated in this process. We have to have a value that only is available in election justice, the equality in all the candidates. And privacy is a value that is embedded in that constellation. This process is not completely done, because privacy was a value understood let's say, in the aspect of personality protection rights. It was different from data protection. So it's still lacking to increase the privacy environment protection, to show the importance of that value, that is the value of the power regulation that once the other. When we have information of the candidate or the voters, those who know that have a power. If it's going to be well managed or not, that's another conversation. But it's there. It's in. I know that you like a chocolate. I have more chances to convince you to eat chocolate. That doesn't mean I'm going to convince you, but I do think that based on the values and the norms, we still have to develop an update of the values that are going to guide us. And that update has not only be philosophical, it has to be dogmatic. We have to really see it in the voter environment. So what appeared today is the application of this 57E. It's an article, very old one. It's to confront the problem of the information, misuse of information of the telephones. So it was to be applied in that moment because it was a residual problem of the use of the email. For example, the use of emails in public agency. Now, the WhatsApp list of all the voters in Brazil, has a high value. So that's why today we are changing the size. So we have to think about that. So we have protection data, protection towards the voters. Very well. We have to do that bridge. Because there are some things, for example, the people that have data protection are in this aspect. We have to really understand equality. When we put data protection in that constellation, it's an exercise from the people to try to identify data protection in that general framework. What is gender equality? What is legal interest? When we're talking about, for example, elections and not a business, in politics, what would be an interest? For example, let's say that political parties are very important and they have a very important aspect to show their political participation, even though we do not agree with them. In a tactical level, we have to build that bridge. That bridge is very important to be built in the insight, in the mind, now in the practice too. And it has to be built in some regulatory adjustments. When we're going to discuss data protection during the elections, we have to see the agencies that are involved. We don't have the same level of dependency as electoral agencies, but limitation of the LGPD, whatever they do is very important to understand up to what extent they can participate. So this is a must, because there is no, in the legislation, there's nothing that says we're going to talk about electoral justice. So it's not related to data protection, even though we had the resolution of 2019 to bring the application of LGPD as a possibility in the electoral justice. This has not been done, and it has to be done. There are a lot of adjustments that have to be built, and reminding that the bridge that you built, in my example, you have to begin to build them from both sides. There's going to be a lot of conflict in that process. When Maximo was approved, electoral justice insisted to apply in its integrity, explaining for those who said that it had to be different. So it was a very conflictive time. Rebecca was here, and she is a witness the change during the past years of antagonism towards collaboration in electoral justice through the internet platforms. This happened because both sides said, we have to talk. Elections are going to, on the other hand, elections are going to be more faster, but on the other side, it is important to understand, to consider that there were very important data that had to be protected. This is not a simple process to build that bridge, but the people, and we are concerned of data protection in the update. We have to update to include data protection in this process. We have to really build that bridge and to work on those problems lacking. I was not very specific on my talk about the principles that would apply and on the details, it makes sense or not. But these are moments in which we should invite other areas of data protections and the people from other areas to see where we're going to work together. Thank you again for the invitation, and we're happy to answer any questions you may have. Thank you very much, Chico. I would like to thank all of you for your participation. Those four panelists were their participation were very important. We still have some time for questions and answers. So please write down your questions on the chat. I'm going to ask 3 questions. Anybody can answer them. Please feel comfortable to answer 1 or 2, or whatever you feel much more comfortable. And for that, be very brief due to the time. The first question would be, what are the interaction styles? What are the features in social networks? Thinking about short videos, memes, new ways of interaction that are different for simply posts. What of those should be observed with much more detail because they have a higher potential to be important forms of misinformation and of fake news in the 2021 elections? What do you feel could be the interactions that should be really observed on the elections of 2022? Second question is, what learnings and achievements, updates do we have on respect to combat against the hate speech in social networks? What learnings in this hate speech are much more relevant today in the fight against misinformation? Third question, does it make sense to think about fake news and misinformation in elections in a way that is different from other types of fake news and misinformation? I'm not talking about specific features, but we're talking about specific tools. I'm not talking about timings. I'm talking about the concept. Does it make sense to separate fake news and misinformation regarding the political elections and towards other areas? If you don't have to answer, just choose one or two. Please, I would like to remind you that we do not have much time. Somebody wants to begin?
Perfeito, vamos seguir a ordem então. Rebeca, muito obrigado.
Yes, Rebecca. Well, to answer the questions are very complex, very sophisticated questions. Regarding the interaction, I would like to say that I believe it's important to observe classification that's done by some specialist, that's content, and to observe the type of content and communication, short videos, memes, or text or an audio. But this is a very important exercise, maybe a very important taxonomy to be built. I think it's important to observe the contents with two other elements. That is the actor and behavior. That mixture of factors can help lead us to think thinking about the elections 2020, we would like to anticipate, but at the same time, that vision for those three elements for communication can help us in the preparation and identifying the risks that may happen. Maybe they will not happen in 2022 elections, but at the same time, yesterday I was in Chico's launching book, and he said that it's important to observe and to think communications and ways the content is being placed on the net and to ensure that space. Many voters say that it's important to acknowledge point of view of the information, and it has a lot of value in the propaganda, elections propaganda, for example, for that candidate numbered with this number or the other one. I wanted to make it a little bit more complex, your question, and to say that this analysis is very important Today, behavior and actors involve bots, for example, or fake accounts. And to reinforce that it's important to analyze and anticipate to problems and to open space of communication and maybe mitigate the problems and make them more secure and transparent. I think that it's very important to think not misinformation, but to think in the elections context. We talked about permanent campaign. It says that all the information of integrity protection
é algo permanente, mas ao mesmo tempo acredito que é importante.
It doesn't happen every 2, but at the same time, it's important the elections context.
Como definir qual é o período eleitoral, definir o que é, por exemplo, a propaganda eleitoral é algo que ainda não tem uma definição, pelo menos na lei, né, aqui no Brasil. Então, acredito que é importante olhar para o contexto eleitoral com um olhar diferenciado, que leva em conta também algumas questões que são mais importantes nesse período, por exemplo.
Has to face questions, or some aspects very important in this period. Debate, information exchange, interference in the debates. I wouldn't say, but I would say that in the elections context, we have to observe it and brings a lot of situations. So we have to define what is elections propaganda, for example. And moreover, it's important in the context of the democratic elections. So thank you very much for your questions. Tiago, do you want to answer?
De maneira bem rápida e sucinta, acho que a primeira pergunta
independente
do formato, e algo que a gente vem acompanhando aqui como uma experiência desse ano, o importante é que as instituições estejam preparadas para lidar com esses formatos novos de maneira antecipada e de maneira mais planejada. Então, independente dos formatos das próximas eleições, eu acredito que essa reflexão é muito importante. Já está muito claro que nas últimas, cada eleição a gente vai vendo formatos novos e que é importante que a instituição não fique olhando só para o que aconteceu na eleição anterior. Então, do ponto de vista, eu acho que o formato seria isso. Com relação à questão de discursos de ódio, isso é algo que me preocupa muito. A gente vive no Brasil eleições extremamente violentas. Eu acredito que as plataformas digitais têm que se aproximar mais de organizações da sociedade civil com relação à segurança pública. A gente tem visto casos assim, pipocando pelo Brasil todo com relação a isso. E acho que a gente precisa falar com mais especialistas de segurança pública dentro desse tema. Eu tive num TRE no começo do ano em Manaus. Eu fiquei muito chateado, assim, triste de ver como processos nas redes têm gerado atos violentos fora da rede. Então, esse é um tema e é uma pergunta muito importante para a gente debater. A gente tem que se aproximar de mais organizações desse setor. Acho que elas estão muito distantes desse debate de maneira geral. E sobre a última pergunta, eu acho assim, né? Todos os dados que nós temos atualmente, eles dizem que o processo de desinformação, principalmente o não intencional, ele é permanente sobre o processo eleitoral. Ele não para. Ele é forte, ele é constante e, eventualmente, processos de desinformação intencional, eles aumentam durante o processo eleitoral. Né? E por isso eu acho que esse debate ele tem que ser eventualmente, tenho minhas dúvidas
I really have
pessoalmente
my
se
doubts
é uma questão
if it's
só do eleitoral.
it's
Tá?
an aspect
Porque,
only of the
enfim, eu acho que isso tem
elections,
atingido
because I
várias
think it
instituições
has
de
impacted
modo
several
geral.
institutions in a general sense.
Mas eu acho que esse é um debate muito
But
importante
it's a very important
de
debate.
ser feito. Só queria colocar sobre essa
So
questão, a gente repara muito, né?
we see
A gente vem atuando que a desinformação
that
não
misinformation,
intencional, ela é
non-intentional
quase
misinformation
uma
is
linha assim que vai ao
a
decorrer do
line
tempo aumentando de pouco em pouco.
increasing
A
bit by
intencional é
bit.
muito clara
The
que ela é uma
intentional one is very
desinformação que dá um
clear.
pico muito
It
rápido, né?
has a
E
huge
que
peak
depois
very
ela
quickly,
cai e
and then it
eventualmente essa
drops. And
desinformação não
eventually,
intencional
that
dá um pulinho, dá um
international
passo para cima.
misinformation
E por isso
just
que a
gives
gente
a
comenta
step
que as
up.
estratégias são
So
muito diferentes,
the strategies
né?
are all very
Nesse
different
sentido. Então,
in that sense.
eu vejo que é muito importante o
It's
debate
very
das
important, the debate
características
and the
desses tipos de
characteristics
processos
of these
desinformativos para deslegitimar o
misinformation
processo eleitoral.
processes
Elas
during the elections.
são importantes de serem contínuas.
They have to be constant and continuous.
Muito obrigado, Thiago.
Thank you very much, Thiago. I'm going to just put a self-service here in the proposals. Misinformation during the elections it's a challenge to apply for example, this during the elections period. It's very difficult. And I think that as a researcher, I see different values. I understand that practices, policies mix a lot. Each one's going to talk about their own experience. From TCE, for example, and hate discourse. And I think we have to differentiate this information during the elections. I'm going to answer the second question. How we are dealing with these types of contexts, behaviors online, for example, is very different. At a certain degree, it concerns me because I think that discussions should be on the legal point of view. Misinformation is, let's say, to define if it's legal or not, it's in the gray area. We're going to regulate behavior, not content. That would be what is proposed. I don't know if that's possible, at least at 100%. We should be much more objective, but I think it's very difficult to compare the hate speech, for example. It's a threat to the elections, yes. How it's being disseminated is confusing towards us because it's more or less the same information. But I think it's very important to really understand that at the end of the day, it's not the same to promote legal content and illegal content. We're simply leaving that responsibility to the public agencies. So I really don't think I answered anything. I just wanted to share my concerns. And again, thank you very much for your information. For the participation of my colleagues was incredible. And well, thank you very much.
Vamos lá. Então, também não tenho pretensão de responder tudo. As perguntas foram bem boas.
Well, the questions were very, very interesting. And we can stay talking about them for a long time. But I'm going to answer the third question. I think that not talking about the elections period, more to say that there's a value, existent value in that discussion that doesn't have to be considered in the others. That is, let's say we have to consider every aspect differently, because depending on each case, we can finish the integrity of the elections. So the elections agency has important agencies, aspects, or departments to deal with these threats. Talking about the features and interaction styles, if the Brazilian voters use more stores or less stores, or TikTok or Instagram, other networks during the next elections, this is what we have to observe. The surveys, the polls that are showing where the voters are. Because where they are, those who want to discuss policies or politics want to go there. Because there are voters who just want to discuss politics and candidates too. Let's say game streaming platforms, and there are others platforms that we have to really observe, because depending on the candidates, if a candidate wants to have a contact surface with the public or whatever, they're going to seek those features and will be observing that frame. So we have to be aware of that area based on the demographic experiences, or the places in Brazil, because when we understand where the candidates are going to be, where, let's say, the swing states, it's there where the battlefield is going to be. And the learnings and achievements are where they lie. So there's a very interesting study, but I really am concerned difference between what we value at the superior courts or even at the Congress level, in the discussion of the Congress, to include that, and how would that be in practice? That's my main concern, because what we have the most in parliaments are political members that don't participate or really do not use, and sometimes they become victim of a hate speech. So when talking about the CPI fake news, they don't have the motive to open a CPMI in hate speech against vulnerable groups such as women, Black lives, and politicians, as if politicians were a protected category. Depending on what we approve, how is this going to interact with a system that is regulated? I'm really concerned on that aspect. I think we have to deal with the culture shifts. I would like to discuss deeper this topic. Clara said that the story of content and behavior is perfect and would solve everything. It helps, although in some aspects, but not all. Thank you very much again, the opportunity. And really, I learned a lot. Thank you very much. Okay, our time is up. Again, I would like to thank each one of you. I would like to thank our 4 panelists for their talks. I would like to thank your comments too. And I would like to thank the organizers of this event, Luca Belli, Danilo. Especially would like to thank our Directorio in this event, the delegation of the European Union in Brazil. With this, I would like you to fill out this survey. Please choose the alternative that you think that are the most relevant tools to face misinformation and fake news.
Quem não respondeu a survey ainda, por favor. Temos aí os resultados. Então,
okay, we had the results. As with 45%, the options to regulate the use of personal data as the most relevant tool and adequate to face misinformation and fake news. And demand from the platforms transparency. It's a reality in Germany, and it's in TL6 2630. We have here the results. This helps us as very relevant information for the public organs in Brazil and departments in Brazil. With this, I would like to end the panel. Have a great day today. Thank you very much.